Benvenuti a tutti, vi ringrazio per la vostra partecipazione. Questa manifestazione si svolgerà prevalentemente in lingua inglese e quindi ora passo alla lingua veicolare, scusandomi per pronunce, errori, eccetera. Dear participants, it is my great pleasure and honor to welcome our guest, Professor Tony Smith, for his lecture about the evolving common law on contempt of court at the University of Padua. Before starting the conference, I would like to briefly introduce our guest to the audience. Professor Smith is a New Zealander by origin and until May 2015 was Pro-Vice-Chancellor and Dean of the Law Faculty at the Victoria University of Wellington, where he remains a professor. For the academic year 2015-2016, he will be the Arthur Goddard Professor of Legal Science at the University of Cambridge. Professor Smith spent much of his academic career in England, latterly at Cambridge, from which university he holds the Doctor of Law, Dr. Legum degree, and where he was the Professor of Criminal and Public Laws and Chairman of the faculty. He is a Life Fellow of Gonville and Caius College. Prior to Cambridge, he was a Reader and Dean at the University of Durham and Professor and Dean at the University of Reading. He was chair of the Committee of United Kingdom Heads of University Law Schools. He also has held visiting professorships at the University of Iowa, Northwestern, Paris 2, at the Institut de droit comparé, City University, London, Auckland and Otago. He is a barrister of the New Zealand High Court, a barrister and honorary bencher of the Middle Temple, and a member of the Media Law Set 5 Raymond Buildings. He is the author or joint author of various books, including On Contempt and an acknowledged expert on that area of law. His books also include Learning the Law and Harm and Culpability. I am now giving the floor to Professor Mario Patrono of the University of Rome La Sapienza, who knows Professor Smith since many years and would like to say a few words of welcome. Please, Professor Patrono.
Io parlerò in italiano e non in inglese. Parlerò del professor Tony Smith, non come studioso di criminal law e constitutional law, ma come dean della Law Faculty della Victoria University di Wellington, Nuova Zelanda. La Law Faculty della Victoria University di Wellington, che è la capitale della Nuova Zelanda, prima che Tony Smith fosse nominato dean, cioè preside di quella facoltà, era, secondo la mia esperienza, che già allora avevo, era una buona facoltà, ma una facoltà che aveva un paio di caratteristiche. La prima caratteristica è che era una facoltà abbastanza anarchica, nel senso che accanto a numerosi professori di ottimo livello, sia dal punto di vista didattico che dal punto di vista della ricerca scientifica e della produzione scientifica, studiosi intensi dal punto di vista appunto della produzione scientifica, come Sir Geoffrey Palmer, già primo ministro della Nuova Zelanda, come il professor Tony Angelo, che ha un cognome che tradisce la sua origine italiana, o come il professor John Preble, professore di diritto tributario famoso un po' in tutto il mondo, che ha fatto una bellissima conferenza qui 3 anni fa, mi pare. C'erano poi altri professori che, pur ottimi dal punto di vista didattico, non lo erano dal punto di vista scientifico, nel senso che lavoravano poco o non lavoravano affatto dal punto di vista scientifico. E poi vi era in mezzo la terza fascia di professori di medio livello. Questo fino a quando è arrivato il professor Tony Smith, il quale devo dire che molto rapidamente, in non più di un paio d'anni, è riuscito a trasformare questa facoltà prima anarchica, in cui ognuno faceva quello che voleva a vari livelli ed alcuni nulla, dal punto di vista della produzione scientifica, ha trasformato questa facoltà in una unità, in un gruppo di lavoro, in una unità di lavoro. Nel senso che con un'opera di stimolo e di sensibilizzazione fatta con grande cura, con grande cautela, senza interventi appariscenti, e però tagliando con garbo ma con decisione alcuni rami secchi, i quali hanno trovato collocazione in altre università, in altre sedi, e rimpiazzando questi ultimi con professori di ottimo livello, è riuscito a far diventare la Law Faculty della Victoria University, a trasformare questa facoltà in una delle migliori facoltà del mondo, nel senso che questa facoltà è al 38° posto nel mondo, che significa un ottimo livello. Questo, ripeto, lo si deve in buona parte naturalmente al professore, a chi ha lavorato, naturalmente ai vari studiosi di questa facoltà, ma lo si deve anche al professor Tony Smith per la sua opera di promotore culturale. Quindi si può essere un ottimo studioso e anche un ottimo stimolatore di ricerca e di studi altrui. Quindi ecco, questa è stata l'esperienza che io ho avuto del professor Tony Smith durante i 3 anni in cui ho insegnato anch'io in quella università, in quella facoltà, fino all'anno scorso, quando poi il professor Tony Smith è tornato a Cambridge, è stato nominato un altro dean, perché per scelta stessa del professor Tony Smith ha preferito tornare a Cambridge, dove adesso insegna e lavora, e quindi questo è quello che io posso dire di lui, e devo dire che come dean ne ho una felice esperienza. Grazie.
Illustri professori, signore e signori, I wish to begin my lectures today by giving some thanks to Professor Riondato for inviting me to give a lecture here today, and to Professor Mario Petrono, my esteemed colleague from time to time in New Zealand, whose good offices made this visit for me to this beautiful city of Padua possible. When I selected the law of contempt of court as the topic of my lecture discussion today, it was not actually done with the intention of offering the law of contempt as a, quotes, an institution to import, which is the title of the seminar. Now, as it happens, I think it's a very good title for the seminar, but it wasn't my intention, as I said, to offer it as an institution to import. And that is because I am wary of the use and misuse, or possible misuse, of comparative law as a source of legal ideas. And such comparative law as I have engaged in during the course of my career has persuaded me of the wisdom of the words of one of my predecessors as holder of the Goodhart Chair in Cambridge, which I'm holding this year, and that was Professor Sir Otto Kahn-Freund, who was a professor of comparative law. I have to say that was at the University of Oxford, but it's probably none the worse for that. But he said this: all rules which organise constitutional, legislative, administrative, or judicial institutions and procedures are designed to allocate power. Rule-making, decision-making, above all, policy-making power. And he said these are the rules which are the most resistant to transplantation. And what I'm talking about today is an institution of the common law, which is part of the allocation of power. And in this case, it's the allocation of a power to the judges to uphold the system of justice by the use of the contempt power. But to continue the quote from Sir Otto, he goes on to say, the use of comparative law as a tool in law reform requires a knowledge not only of the foreign law, but also of its social and, above all, its political context. And I would have to confess at the outset that my knowledge of Italy and Italian law and politics is not such that I could claim a degree of familiarity that the injunctions of Professor Kahn-Freund require. Now, it happens to be a matter of some regret to me that I've never spent a protracted period in Italy, in your beautiful and cultured country, but that is why I am diffident about the idea of being seen as somebody who is offering the law of contempt as an institution that it might be possible to import. But that said, the law of contempt is an important, if somewhat misunderstood, institution of the common law, and it applies, I might say, in New Zealand and America and Australia, Canada, all of the common law countries. It's common to all of them, although with probable significant variations. But what I shall do in the lecture is do my best to explain what it is, how it works, and say something about its strengths and its weaknesses, sufficiently for us to have some meaningful discussion and interchange at the end of my presentation. So with those preliminary remarks, let me begin by addressing the issues. What purposes does the law of contempt seek to achieve? Now, speaking very broadly, there are two forms of contempt. There is civil contempt of court, which is essentially directed to ensuring that the orders of the courts are obeyed. That's civil contempt. A person is guilty of a civil contempt which might involve imprisonment if they fail to comply with the orders of the court. And there are procedures by which that process can be implemented. Now, I'll return to that and elaborate on it in a moment. The second version of contempt is criminal contempt. And that's aimed at preserving the integrity of the criminal trial in particular. Now, the British conception, and the common law conception, I would say, of a fair trial, is that a person is entitled to be tried in serious criminal cases by a judge and jury, and to be tried only according to the evidence that is presented to and tested in an open court. So we have at the core of what it is to be protected in the law of contempt, criminal contempt, the notion that the fairness of the trial might be jeopardised in a variety of ways, and it's the role of the law of contempt to protect the individual who is the subject of the criminal trial. And allied to that, a rather more amorphous notion, which is that it is to preserve the administration of justice more generally from improper interferences with the judicial process. Now, in both of those cases, civil and criminal, the power of the courts to protect their processes is said to be part of the inherent power of the court. It is what the judicial process involves, that it has an inherent power to protect itself. And so when Freund was talking about power, that is the power that is operated by the judicial system, and which it might be not easy to transplant into a different jurisdiction. It's a somewhat difficult concept to unpick in a lecture such as this, because it has constitutional underpinnings as part of the doctrine of the separation of powers. The doctrine of the separation of powers in the United Kingdom, at least, operates on the basis that the judges are independent in particular of the executive, independent of the legislature, and the contempt power is something that enables them to protect themselves and protect their own independence. So any attempt to effect a wholesale reform of the law of contempt in England or in the United Kingdom or indeed in New Zealand, as by codifying it, putting it into a codified form, would have to accommodate the anxieties of the judiciary that something fundamental to their part of the Constitution might be being put at risk. Perhaps, though, I should also begin by saying something about what contempt of court is not about. The language used to describe the institution is somewhat misleading. A dictionary of the English language would tell us that contempt involves holding an individual person or an institution in low esteem, as not being an object whose dignity is entitled to respect. But that's not what it means to lawyers. And I'm going to quote from the language of the principal encyclopedia, if you like, the Laws of England, Halsbury's Laws of England, which it puts it this way. It says, the phrase contempt of court often misleads persons who are not lawyers and causes them to misapprehend, misunderstand its meaning, and to suppose that a proceeding for contempt of court amounts to some process taken for the purpose of vindicating the personal dignity of the judges. And it has been made plain time and time again that the personal dignity of the judges is not the object to be protected. Rather, it's the administration of justice that is the object of protection. And if a person acts in a way that defeats or interferes improperly with the administration of justice, that is the contempt. The topic that I'm addressing is the evolving common law of contempt. And I will be saying a certain amount about recent changes to the law of contempt. There was, until relatively recently, a species of contempt known as scandalizing the court or a judge. Scandalizing the court or a judge. And that meant an attack on the individual judge, not a physical attack, but an attack on the reasoning that the judge used in intemperate language. The Scots, by the way, they're part of the United Kingdom, but their law of contempt is in many ways rather different from the English law of contempt. They have an institution called murmuring the judges, not scandalizing, but murmuring, and it means much the same thing. But in reality, that form of contempt had not been used in England for over 100 years. No person had proceedings brought against them for scandalizing the judge, for saying something about the judge, which was an assault on the integrity of the individual judge. But increasingly to the modern eye, it nevertheless appeared to afford the judicial process some protection from legitimate scrutiny to which the judges have long been open. It was said as long ago as the year 1900, judges and courts are alike open to criticism and if reasonable argument or expostulation is offered against any judicial act as contrary to the law or the public good, no court could or would treat that as contempt of court. Now you notice that what's said there is that judges are open to criticism, and if reasonable argument is offered, as that the judge has done something contrary to the public good, no court would treat that as a contempt of court. But even that, to modern eyes, even that assessment was recently thought by many experts to afford more protection than was really necessary in a healthy democracy. Why should citizens not be permitted to offer unreasonable argument or expostulation about the language of a judge just because the person happened to be a judge? If judges are unfairly criticised or they're accused wrongly of serious misconduct, they have the protection of the law of defamation like any other citizen. Now, I personally believe that there are some difficulties with those arguments, both practical and arguments of principle, which we might possibly discuss later. But I have to say that the tenor of the times is such that the government was persuaded to refer the matter to the English Law Commission, which is the law reform body in England, and it was recommended that this form of contempt should be abolished. And Parliament acted on that recommendation very rapidly, enacted the Crime and Courts Act of 2013, and that abolishes the law of contempt, at least by scandalising. That does open the possibility, as I say now, that if a judge is made the subject of defamation or claimed to have been guilty of some serious misconduct, then it cannot be proceeded against by the Attorney General by way of a scandalising procedure. It will be open to the judge, him or herself, to have to bring proceedings in defamation, and I think that's got some serious difficulties given that, the defamation law in England is one, extremely expensive, and two, likely to take a huge amount of the judge's time and energy. You can expect it to take anything like 18 months, and the judge wouldn't have much time to do much judging in the meantime. So I think that the judges, by the abolition of that form of contempt, are possibly left in a more vulnerable position than they were before. I think most of the judges would say, well, so be it, we probably didn't need it. But I'm one individual who was a bit surprised to see it go quite so readily. Now, turning to civil contempts, the law of civil contempt is seen by common lawyers throughout the common law world as being fundamental to the maintenance of the rule of law. And this is true in two respects. It's a coercive force that lies behind the principle that court orders must be obeyed unless they are appealed against or properly set aside. Once a court order has been made, the citizen has no obligation but to comply with it. He or she can appeal against it and apply to have it set aside, but it is the point at which the judges insist that the administration of justice can be protected properly only if people comply with their legal obligations. Now that operates in a wide variety of contexts, as wide a variety of contexts as there are types of litigation, but it often arises in family law, domestic disputes, areas of that sort, and quite frequently in civil litigation relating to financial transactions, intellectual property areas of that sort. And the judges are quite clear that the rule of law is in jeopardy and at risk if the orders that they make can be flouted without any kind of repercussion. And the procedures by which this is initiated are, in fact, by the parties to the proceedings. It's a civil contempt because it's the parties to the proceedings who bring the allegation of contempt, and it's a motion to commit the other party to prison for failure to comply with the court order. Now, it is buttressed about by significant protections for the person who is likely to go to prison. That is to say, the evidence that must be produced has to be very clearly identified, and the respects in which the breach has occurred must be identified with considerable precision. The paperwork that must be served by the person seeking to commit has on the front of the papers, "You are at risk." This is a penal notice. You are at risk of imprisonment if you do not comply with this court order. And it arises in situations, for example, in a commercial dispute where the judge has ordered that the party to the dispute, one of the parties to the dispute, must make full disclosure of his or her assets as part of the transaction. It will often be in the course of a dispute where it is claimed that a contract has gone wrong. The claimant is asking for a huge amount in damages, claiming that the contract would have resulted in this amount of money. At that point, the defendant will be asked to give a full account of his or her assets. Failure to comply with that order, or failure to comply with it candidly, honestly and truthfully, can very often give rise to proceedings for contempt. I've acted for somebody who got put in prison for 2 years for precisely this sort of thing. He skipped the country before he did go to prison, but 10 years later he decided he'd like to come back to England. What was the risk that he might be put in prison for contempt if he came back? So it's a drastic remedy. I should tell you, though, that it's less drastic than it used to be. At common law, the period of imprisonment for which a person might be committed was said to be, quotes, at large, meaning indefinite. You simply got put in prison, and they didn't quite throw away the key, but they said, you've actually got the key to your own imprisonment in your own pocket. And if you come to the court and comply with the order and apologise, then you can be discharged from imprisonment. That was altered by the Contempt of Court Act in 1981, when the maximum period was set at 2 years imprisonment. Technically, if a person was put in prison for 2 years and didn't purge the contempt in that period, he or she could be put back in prison for another 2 years. But I'd never known it to happen, and usually common sense prevails by proper legal advice and understanding. So this species of contempt is referred to, as I've said, as civil contempt, and its purpose is said to be coercive rather than for reasons of punishment. You're put in prison because they're trying to force you to do what the court has required you to do, although I have to say that the distinction between being forced to do what you're told to do and being punished for not doing what you're told to do may not be all that obvious to the person who's subject to the court order. But in family law disputes, there was one respect in which the law was open to quite serious criticism, and that was that the proceedings for contempt and imprisonment arising from family disputes were frequently held in private. Now, these sorts of disputes are usually held in private because of the interests of innocent parties in family disputes, generally the children. So they've got warring parents to be protected. But when it was sometimes giving rise to imprisonment for contempt of court, because the husband usually was failing to comply with court orders, but so I say usually the husband, but sometimes the wife, for example, who absconds with the children, even though she's been told to hand them over to the father, something like that. It meant that a person could be put in prison in private proceedings. And it was thought that that was utterly improper, and about a year or two ago, the new president of the family court had the rules of court changed so that these proceedings are always held in public, and the press can be there to report them. And very often, of course, the press like to be there to report them if it's the children of, or if it's celebrities squabbling, as it not uncommonly is. And the courts, reporters can be there. The courts, though, do have a power to prohibit publication of those legal proceedings. They'll prohibit the fact that a person has been put in prison and the reasons why that person has been put in prison, but without necessarily detailing who it is, who is the subject of the proceedings. And that's not a bad example of the way in which the courts can themselves, by the use of amendments to the civil procedure rules, can actually affect the substance of the law of contempt quite significantly. It's the sort of adjustment that's possible with the common law system. Contempt of court is historically the product of the common law. It's been crafted over the centuries by successions of judges using common law methods and the doctrine of precedent. As with all areas of the common law, it's constantly changing and adapting to altered social circumstances and developments. Now, turning to criminal contempt, that's committed by a person who interferes with the administration of justice in some way. And that can take many forms. It could involve, for example, threatening either a witness to the proceedings, or making improper threats to a party to litigation. If you do this, I will tell the police that you have done this, that and the other. Improper threats that have really nothing to do with the litigation in question can be treated as a form of contempt. But one particularly controversial use or problematic use is to prevent the publication of material, usually by the press, that is prejudicial to a person who's facing a criminal charge. Now, as I said at the outset, we believe that the only proper way in which a person can get a fair trial in accordance with both the common law and Article 6 of the Convention is by a hearing in public in which the person is tried solely on the evidence before the judge and jury. So a publication that would infringe in this sort of area might take the form of publishing details of the defendant's previous convictions, when those convictions might not be admissible at the trial itself. So if the press were to do that, that could give rise to a charge of contempt. But one area of technological development, if you like, that has profoundly affected the law of contempt has been the rapid change in communications technology. I referred above to the press, but the truth is that with the astonishingly rapid development of social medias, bloggers, Twitter, Facebook, and the other forms of communication, ordinary citizens can reach audiences just as extensive as those in the printed form. Another dimension of this is that the familiarity with search engines such as Google now mean that a potential juror is able to go onto the net and quite easily find out about the background of the person he or she is about to try in the criminal case. It is, as we all know, incredibly difficult, simple rather, to obtain material of that sort. So what do we do about the potential juror who's conducting his own research, in inverted commas, into the case that he or she has sworn to try solely in accordance with the evidence? It really is a problem for a system which operates with a jury. So what do we do? Now, in fact, the problem got so pronounced that Parliament intervened in legislation, which I'll talk about a little bit later, and made it a criminal offence for a juror to go on the internet to search for information about the case which he or she was going to try. Now, of course, one of the problems is how are you ever going to find out that that is what the juror has done? And the few cases that there have been have involved jurors telling their fellow jurors that that's what they had done, and those jurors then let the forces of law and order know what they've done. And that was held to be at common law a contempt of court, because it's an interference with the process of justice. The mention of rights brings me to, I think, another huge change that has affected the law and procedure of contempt of court, namely the enhanced importance of the rights of the individual accorded in the latter part of the last century, which culminated in UK law anyway, in the enactment of the Human Rights Act 1998, which incorporated the European Convention on Human Rights. Now, it's at least arguable that it was a decision of the European Court of Human Rights in a contempt of court case, the Sunday Times case in 1979, that alerted the British public and the press as to the latent power of the European Convention. That decision was one in which the European Court found that the common law was in breach of Article 10 of the Convention, the right to freedom of expression, because it did seem to forbid the press from reporting on either upcoming cases and so forth. So the Contempt of Court Act in 1981, the purpose of that was to bring British law into conformity with the European Convention. And as it did that, it gave the press considerable opportunity and scope to criticise the common law of contempt and call for changes to the existing law. Now, in 1966, the United Kingdom had adopted the right of individual petition to the European Court, but it had hardly ever been used prior to the Sunday Times case. And once it had been used, then it was used with increasing frequency in the United Kingdom, the individual petition to the European Court, leading to increasingly strident calls for the Convention to be incorporated into British law. And of course, as I've just said, it was incorporated. Now the tide has turned. As you may know, the present Conservative government adopted as part of its recent election manifesto a pledge to repeal the Human Rights Act and replace it by a British Bill of Rights. Now, I mentioned the problems.
Is this a project or a law?
It's only a project still. Yeah. And it's a highly contestable project, as you might suppose. The idea that we would in the United Kingdom withdraw from the European Convention because several decisions have gone against governments, successive governments, particularly in immigration, terrorism cases in particular. I don't know where that's going to go, to be honest. Personally, I very much hope that we stay within the regime and find ways of accommodating ourselves rather better to the European Convention. But just going back to my example of the use of Twitter and so forth by jurors and other people, the Attorney General of the day, and it's the Attorney General who by and large enforces criminal law, contempt, actually went on to Twitter and Facebook to alert people to the dangers of using Twitter and Facebook in ways that might very well give rise to criminal convictions. There have been several cases. A man, for example, posted images of two notorious child killers whose identity had been assiduously protected by court orders. And these Twitter and Facebook posts were clearly in breach of an injunction protecting the killers, whose lives would without question have been in danger. They were given police protection when they finally got out of court. Their lives would have been in danger if they'd been identified. Somebody would want to kill them. They behaved, I mean, their crime was just appalling. And so these people were convicted of contempt. Rapid and sincere apologies after the seriousness of what had been done was pointed out, plus mitigating circumstances, personal circumstances, saved them from a substantial period, I think, behind bars. How are we doing for time?
Oh, you have all time.
We've got a wee bit of time. I should say that our law of contempt has been before the European Court of Human Rights on a number of occasions and in a number of cases. And it's been quite interesting to see the European Court delve into the internal practices of the United Kingdom's criminal justice processes. What has happened is that it's been faced with a string of claims that the jury system was vulnerable to hostile and prejudicial pre-trial publicity. So, I've been talking earlier about how the press is constrained by the law of contempt from publicising prejudicial pre-trial material. It's a very good argument for the convicted defendant to say to a court, look, you've held that these people were in contempt of court. I was convicted as a result of their prejudicial publicity. Now you've got to quash my conviction because of the prejudicial publicity. I was unfairly tried. I did not get a fair trial under our own common law or under Article 6. But in fact, what the English courts have increasingly done is to say, no, we can manage the prejudicial publicity. And then when the case goes to the European Court, the government has in effect to explain what the processes of protecting the court's processes have to be adopted so that the trial finishes up being a fair one. And there have been a number of cases in which people have gone to the European Court. Mustafa Abu Hamza was one. Some of you might know that he's the chap with one eye and the hook, the Islamist person who was thought to be he was convicted of various kinds of incitement to terrorism and so forth. Well, he was a gift. He had one eye, a hook. He looked as he was. Not from the United Kingdom jurisdiction, if I can put it that way. And there was a huge amount of highly prejudicial material about him. And so he went to the European Court of Human Rights to say, look, I did not get a fair trial. And the European Court has dealt with that in a very interesting way. It looks in some detail at the English trial by jury. And it says, the court commences its deliberations with the assertion that these claims that not to have got a fair trial must be assessed having regard to the composition and constitution of the trial tribunal. And then the court starts with two key and quite critical presumptions. The first is the presumption that whether it's judge or jury, there's a presumption that that tribunal is an impartial one, as Article 6 of the Convention requires, in the absence of any evidence to the contrary. It operated also on the further presumption that the jury were capable of following and obeying the instructions that had been given to them by the judge when it came to the evaluation of any prejudicial material that they may have encountered in the press, again, in the absence of any evidence to the contrary. So if you're going to the European Court and saying, I didn't get a fair trial because either the jury was biased or the judge was in some way affected by this prejudicial material, you're met at the outset with two, I think, perfectly reasonable presumptions that unless you've got any evidence to show that the judge was biased or the jury was biased, then as far as we're concerned, the trial was, on that matter anyway, a fair one. Well illustrated by a most recent decision of 30th of June 2015, decided by the European Court of Human Rights, Fourth Chamber, in a case called Abdullah Ali and the United Kingdom. The applicant had been convicted of conspiracy to murder, but the jury failed to return verdicts on other counts, so they couldn't agree on the other counts, but they did convict of conspiracy to murder. Following the verdict, there was a huge, widespread media coverage, which a judge later described as an avalanche of objectionable material. But notwithstanding that, a retrial of the other counts was then held. The applicant argued that the earlier publicity had rendered the retrial unfair, and that was rejected. The court referred to factors such as the lapse of time between the publicity and the retrial, that had been, I think, something like 18 months, something like that, as well as the ability of the jury to follow the judge's directions and the practical steps taken by a trial judge to ensure a fair trial. I should say that when this started to become a problem some 10 or 15 years ago, trial judges were in disarray as to how to deal with it. Some trial judges didn't tell the jury anything about what to do about prejudicial material. And that problem became more acute as that prejudicial material potentially became available to people through Google and so forth. But the judges who refused to talk about it said, look, we don't want to put ideas into their minds. If we tell them not to go hunting on the internet for prejudicial material, we're suggesting to them that they can do something that it hadn't occurred to them to do. So it's best not to say anything. Now, the reality is, I think, otherwise. And so what judges are now required to do is tell the jury that there might be prejudicial material, tell the jury that some of that material is quite likely to be erroneous, inaccurate, and in any event, it hasn't been put in front of them for the purposes of the trial. And you can say to the jury, it just would not be fair to try a person on material that he or she has never been invited openly to confront. And they simply have to trust to the jury. And that's what the European Court of Human Rights has been saying is the guarantee, if you like, of a fair trial using our law of contempt. So, as I indicated earlier this year in the Criminal Justice and Courts Act of 2015, the courts, again advised by the Law Commission, and they make it a criminal offence for a person to, in effect, go and conduct his or her own research. It's a criminal offence to disclose the results of that research to any other person, whether it be juror or any other person. Jurors are told not, when they go home, to talk about what's happened in the trial. They must not discuss it with any people other than the jurors. So, in all, there are 4 new criminal offences. I won't bother you with the detail. 4 new criminal offences to deal with juror contempt and misconduct that are created by the Act. It's difficult material because to know whether or not a juror has done what he's alleged to have done, it may be necessary to talk to other jurors and ask them what, if anything, the juror has said to them, what, if anything, occurred in the jury room, the secrecy of which is something that's very jealously guarded. The offences carry 2 years imprisonment, and I wait to see just how well they work. I had considerable reservations about using the criminal law against jurors in this way. Jury service is as it is, a singular imposition on an individual citizen's life, particularly if it's a long trial. They are, a long fraud trial, but some of the long conspiracy and terrorism charges these days can take weeks and months out of people's lives. The idea that they can, at the same time, be threatened with imprisonment themselves if they make a mistake or do something that they shouldn't have done in the course of it. So it's one of the very important aspects of it, I think, that what the judges can say and what the judges must say is now much more clearly articulated to the judges themselves, so that they emphasise to potential jurors and jurors what it is that they should and shouldn't do, or shouldn't do mainly. Just one more aspect of contempt which I probably ought to mention is contempt in the face of the court. That is contempt which is a criminal form of contempt, and that involves disruption by a person in court of the court proceedings, often in a criminal case by the defendant, but might sometimes be somebody in the public gallery, or again often a relative of the defendant, or sometimes a family member of the victim. They dislike something that's done by the judge or they've seen to happen, and so they cause an outcry in the courts. Now that technically is a contempt of court. There's a very old case in which it's reported only in medieval French. It's so old, and it's known as the brickbat case. And it was said that the defendant jet un brickbat at the judge, qui narrowly missed. He threw us up whatever it was, a brickbat at the judge, and it just missed the judge. And he was found to be in contempt of court and executed for his trouble. That's how seriously they took contempt of court in the medieval period. But judges have long had the power to control proceedings in their own courts. But it can be argued, I think, and has been argued, that there are dangers with the use of the contempt sanction in these circumstances. It doesn't look, in particular, if the judge is dealing with it him or herself, as though there's a necessarily independent and impartial person hearing the contempt proceedings. And again, in the last, I would say, 15 years or so, the procedures have been modified very significantly, so that although the judge has got power to quell the interruption and, if necessary, put the person in a cell for a short time, if contempt proceedings are then going to be used, there are all kinds of constraints that surround the use of the contempt procedures. And in particular, the higher courts have insisted that a judge who should not use the contempt sanction without there being what they refer to as a cooling off period. You can't say to somebody, as the judges used to do, you now committed contempt and so you're in prison for the next 2 weeks or 3 weeks. That used to happen. They could do that. But the rights of the individual, I think, are such that there might be all sorts of explanations for why the person behaved as he or she did, but also a person who is going to be used, or dealt with rather, by the use of the contempt sanction has to be advised of his or her rights, to have legal advice in relatively serious cases, proper legal counsel, and it's considered better to have the matter dealt with by a different judge, with evidence, if necessary, from the trial judge, if that can be arranged, so that the judge is not seen to be a judge in his or her own cause. So there's an overview, a brief overview, if you like, of this multifaceted concept of contempt of court. I've been, dare I say it, fascinated by it as a topic since I was a student in New Zealand many years ago, and I originally went to England to write a doctoral thesis on the law of contempt, but as I hadn't got into it for very long before I encountered another person much more senior to me, who was about to write a great big book on it, and that was the end of that. So I went and did something else for the next 20 years, but then I got back to contempt and have myself now written a major book on the subject. So that's, as I say, an overview, but I go back to what I said at the outset, that my knowledge of Italy and its institutions is not such that I am prepared to say that the law of contempt is an appropriate import. But it would be of great interest to me, at any rate, to hear how the Italian legal system deals with some of the problems that I've described. Maybe some of them are absent because of the differential use of jury systems. But how does the Italian legal system deal with a litigant who refuses to comply with court orders, whether the order's made in the course of proceedings or at the end of proceedings? How does the Italian legal system deal with the possibility of prejudice to a person who is being prosecuted with a serious criminal offence? So there are some of the questions I think I would like to pose, but I understand that other questions are going to be asked of me, so thank you very much for your attention.
Thank you very much, Professor Smith, for your very interesting overview of the law of contempt, which helps us to better understand an institution that has an ancient tradition in the common law and that raises a lot of fascination among the civil law scholars. I think that this fascination often goes hand in hand with a certain amount of confusion of what contempt of court really is. Here is why I particularly appreciate your lecture, because I think that it is necessary to have a clear picture of the peculiar characteristics and of the critical issues concerning the contempt of court, such as the one you gave us. In the Italian legal system, with the expression oltraggio alla corte, we usually refer to the offense to the dignity of a single judge during a hearing or to the honor and the prestige of the judiciary on its whole, even though in this latter case the object of the protection is the proper functioning of the public administration. But as we have learned by the words of Professor Smith, the contempt of court in the common law is something different and broader. The personal dignity of the judges is not the object of the protection. We get the impression of a very complex institution with various possible applications. It seems to be a very broad concept that encompasses many heterogeneous conducts, from the non-compliance to an order issued by a court to any improper interference with the administration of justice, including the publishing of documents or materials that can be prejudicial to the fairness of a criminal trial. The two forms of contempt, the civil contempt and the criminal contempt, have, as far as I understand, a different nature. The criminal contempt has essentially a punitive character, while the civil contempt seems to have a dual character, both coercive and punitive, even though they both have the common purpose to preserve an efficient and impartial system of justice. It seems to me that the civil contempt law aims to protect directly the interest of a private to the enforcement of the obligations imposed in his favor by the court in a civil proceeding. And only indirectly it protects the public interest to an effective administration of justice. We maybe can say that the civil contempt is a sort of a quasi-criminal offense, and that the criminal sanction seems to have, in this case, also the nature of a remedial rather than just a punitive nature. In any case, the distinction seems to be clear in principle, but I wonder if it is always so easy to distinguish the criminal contempt from the civil contempt in practice. I also wonder, and I asked Professor Smith about this, if there are significant differences between the two forms of contempt with regard to the procedure of application of the criminal sanction and with regard to the guarantees for the individual. With specific regard to criminal contempt, I think that this institution can raise many concerns among the civil law scholars. As Professor Professor Smith told us, criminal contempt is committed by a person who interferes with the administration of justice in some way. It may take many forms, and it encompasses any conduct that may undermine the preservation of an efficient and impartial system of justice. This means that a great discretion is permitted to the judges in determining what the contempt is. This broad power of the judges undoubtedly allows an adaptation of the law of contempt to the changing social circumstances and developments, as it happens with regard to the rapid evolution of communication technologies with clear benefits for the correct administration of the justice. With this regard, Professor Smith reported us some interesting cases concerning the misuse of information and communication technologies by the members of a jury, Google, Twitter, Facebook. On the other side, the great extent of the contempt powers of the judges in the common law system could, from the viewpoint of the continental lawyer, entail the risk of a dangerous compression of the fundamental rights of the individual. For example, the risk of prejudice of the right to free speech in the field of the contempt by publication, as it emerged in the case of the Sunday Times versus United Kingdom. In the Italian criminal law system, we do not find an institution that fully corresponds to the contempt of court as outlined in the common law. At the beginning of his lecture, Professor Smith reported the word of Professor Canfreund about the use of comparative law. I agree with the idea that there are some rules which are most resistant to transplantation, and that is why we put a question mark in the title of this seminar after the phrase "an institution to import." The answer requires a deep reflection, because contempt of court is a typical institution of common law, and it is strictly connected to a judicial system that is very different from our own system. It implies the exercise of discretion that seems very compatible with the structure of our legal system and with the functions of the Italian judge. In any case, a discussion about the strengths and the weaknesses of this institution can be a profitable occasion to stimulate the critical reflection on the adequacy of the Italian criminal law institution to protect the interest to a correct and efficient administration of justice. Therefore, I thank once again Professor Smith, who gave us the opportunity for such a reflection. And I give the floor to Professor De Poli, ma un momento solo, prima, magari se vuoi, Deborah, sederti qui perché poi parlerai tu. Tu parli, poi Mario.
2 parole.
E poi lasci il posto, poi sortì, magari.
Thank you very much, Silvio, for your invitation, and many congratulations, Professor Smith, because let me start by saying that when Silvio phoned me and told me, Matteo, would you like to intervene in a debate regarding a speech, after a speech on contempt of court, I told him, Silvio, are you kidding? I'm a professor of banking law. What can I say regarding contempt of court? But after this short, I think, funny episode, I have to tell you that with the interest that I have, with something that I have to learn, I've accepted to be here with you to listen to your very good report, very good speech, because it has been the occasion to think about. Not necessarily to the contempt of court that I don't know, or I don't know so well to expose to the public my opinion, but to some areas of Italian experience needing for, I don't know, an importation, but thinking about the possibility to exploit also the experience in common law of the Institute of Contempt of Court. But let me speak off the cuff, because I've not written anything and I want to speak freely regarding my suggestions, my impression concerning contempt of court. Well, I would say that first of all, I just ask you if so, I wonder if the system is efficient, because Italian legal system is full of remedies, is full of penalties, is full of sanction, notwithstanding this enormous amount of sanction, penalties, rules, and so on. The legal system is not efficient. So, first of all, as far as I can understand, regarding the contempt of court if imported in Italian legal system, I don't know if it could be an efficient tool to prevent the aggression against administration of justice, the something that interfere with the freedom, the autonomy of judges, and so on. I don't know. This is not a rhetoric statement. Really, I don't know. I think that Italian legal system is a system that has everything, but is full of rules, is full of sanction. But as something doesn't work, perhaps all of us have to think if it's helpful, a further and an additional tool as contempt of court. But let's suppose that we need for critical interpretation of contempt of court. As for the areas, the territories of Italian economic and social experience that I need to take into account also with the tool of contempt of court, I would say, first of all, Italian lawyers are extremely aggressive against juries.
We didn't hear the word. It's a jury.
Italian lawyers are extremely aggressive when debating in front of a court. But as far as I have understood, this is not a matter of contempt of court. No, very well. Yes, I agree. Secondly, Italian experience shows something that I think is interfering with the administration of the justice in a very severe manner. And I mean, and I'm thinking about television broadcasts making a parallel trial in competition with the official one, exactly in competition, and very frequently also in national television broadcast, followed by many people, guided by good journalists, whose hosts are lawyers, consultants, experts, former judges, and so on. Every day, every night, during an important for the public trial, we can see the parallel one in television broadcasts. This is, in my opinion, an experience that should be prevented or regulated, but one more time, it's a criminal charge the best tool, or it should be regulated by the provider of the broadcast services, for example. I'm going to ask you, I'm asking to all of the participants do you think that we should insert an additional criminal charge against, for example, Bruno Vespa, that all of us know as a journalist leading such television broadcasts? Very well done, very well done. So, one more time, I'm wondering if a new criminal sanction is the best tool to prevent or to give a remedy against these incredible situations. Thirdly, and finally, there is a third territory, a third area, and it's the disobedience to court orders. Well, regarding the disobedience against court orders, I do agree that a criminal charge is needed, a criminal sanction is needed. Because if you allow to think that a court order is weak, and is weak because you can adopt it, respect it, or not, without efficient, and I mean by efficient, a severe threat and sanction, even the state is weak. And this is against democracy, because our democracy needs legislative system, efficient, honest, and so on, but definitely it needs also a judicial system with a good prestige. Let me finish by saying that it's also a matter of, it's a cultural matter. It's a cultural matter. In the last 20 years in Italy has emerged dramatically a tendency to challenge judicial system, and it has been it emerged also officially, as you can imagine. You can imagine what I'm thinking about. Well, if we don't turn such an opinion concerning judicial system, my opinion is that neither a criminal sanction could be sufficient. This is my point of view regarding this concept.
Maybe Professor Tony Smith would like
could answer to this question.
Pose some questions.
Well, thank you very much. Both the professors who've spoken so far for picking up the points and the challenges that this area of the law represents, and if I may say so, there have been some astute comments on some of the problems with this area of the law. One that Professor Riondato picked up was that civil contempt is mainly concerned with private parties, and that is in some ways its strength, and I think in some ways it's a strength that addresses some of the problems that Professor De Poli also has with it. In certain cases, a judge might take the proceedings himself, and one case I can think of was a case where the Inland Revenue, i.e. the government, did not comply with the court order. And the court, the government is as much obliged as any other private citizen to comply with court orders. We had a major decision of the Supreme Court, the House of Lords, many years ago, when a minister said to the courts, "I'm not obliged to comply with your court orders." And the answer was, "Oh, yes, you are, and you'll get put in prison too if you don't comply." And normally, of course, governments, the executive, have no difficulty. But the case I'm thinking of in particular, where the judge thought that it was necessary for him to refer the matter to the Attorney General. The Attorney General is the individual officer of the law. He's the officer advising the law. He's a member of the executive, not a member of the cabinet. he can be invited to look at the circumstances by a judge to say, I think that you should bring proceedings against the Inland Revenue. And that will be because the party who has been injured by what the Inland Revenue have done won't particularly want to antagonise the Inland Revenue even further by bringing contempt proceedings against them. It could do, and if he or she was really hard-nosed, but if the individual in whose favour the order has been made, for one reason or another, doesn't want to bring contempt proceedings, and that can happen in domestic cases, for example. A wife will frequently think, oh, well, I don't want to antagonise him by bringing contempt proceedings, then it can go to the Attorney General, who will bring the contempt proceedings. And that also answers your question about the efficiency of the system. Yes. It is because it relies on the interests of the private person. They have got a judgment saying they're entitled to this, this, this and this, and that the opponent must do this, this, this and this. The state, in some ways, doesn't have a particular interest in that particular judgment being executed. It's not a first line a problem for it, but it is for the person who's won the... And so what the person can then do is invoke the intervention of the justice system, and once you've gone through the processes, then the procedures for actually imprisoning the person are really quite simple and rapid. I mean, there will be somebody at the court door prepared to take the person and put them in prison that day if they don't come to a satisfaction.
Without any exception?
Pretty much without, yeah.
Okay.
Yeah. I mean, if the person was particularly old or something like that, then the courts might say no, but we might be able to distrain on his or her assets or do something of that sort, which can be done again by public officials at the behest of the court, and because the court's required it to do so. So I think I can't point you to any empirical evidence about the efficiency question, but certainly it's a weapon or an instrument that makes people very, very cautious indeed about not complying with the court order. And I told you about the client I had who was in Lebanon, actually, and he wanted to come back. And he had failed to comply with the court order requiring the disclosure of all of his assets. He had property abroad, which he hadn't mentioned. He, though, settled the arguments that he had with the company with which he was in contractual dispute, paid them all the money. In fact, he hadn't paid them quite all the money, but he was willing to do that. But to do that, he had to come back to England. He didn't want to come back to England if the courts were going to put him into prison for contempt. And it was resolved by the judge. Eventually, he went to the judge, and the judge said, there is no public interest in this person being put in prison for contempt of court. He's dealt with, he's done exactly what the court told him to do, he's apologised, and so forth. So it's settled in that way. You mentioned the overlap between civil and criminal contempt, and I alluded to it obliquely when I said, well, if a person gets put in prison for a civil contempt, it doesn't much matter it's a civil or a criminal contempt as far as he or she is concerned, they're in prison. And in the Supreme Court of Canada and then in the Supreme Court of New Zealand, they have more or less said, in certain circumstances, when a person is being dealt with by way of civil contempt, the protections that they should be accorded are the same as for a criminal contempt. And in Canada, in one case, the Supreme Court of Canada about 30 or 20 years ago, they did say that a civil contempt can become criminal if the failure to comply with the court order is persistent and flagrant and, in a sense, almost contemptuous, a deliberate flouting of the law which the person could easily comply with. So there is a very difficult overlap between civil and criminal contempt at that sort of area. The general idea is, as you rightly distilled from my lecture, civil contempt, failure to comply with the court order, criminal offence, interfering with the course of justice. And so that comes back to your point, Professor DePauli, about obedience to court orders possibly requiring the use of the criminal sanction. Well, we don't use the criminal sanction, although it looks as though we are using it, but it's a civil contempt, but the person can go to prison for it. So it's not quite that he doesn't have a criminal record, for example. In the old days, they used to treat them differently in prison from people who went because they were convicted. That's less of a distinction now. But it's the fact that the triggering of the use of it is at the behest of the person who's otherwise going to lose out that really makes it an efficient system. They can go back to the court and say, look, he's not doing what you told me, I want you to put him in prison, and the judge will. And you have to come up with a very good story as to why the judge shouldn't do that. And as far as the parallel television broadcast is concerned, and you raise the question, I think it's a perfectly fair question, is the criminal law the best way to stop this? I would say no. The best way to stop it, in my view, would be to go to the European Court of Justice and say, look, this is violating my Article 6 rights. And I reckon even the European Court of Justice might say, you show us that your procedures in the criminal case have been sufficient to negative the possible inference that this is an interference with the administration of justice, and a person's not getting a fair trial if that sort of proceedings is afoot. But I think that's answered, or at least addressed.
Thank you. Se chiamiamo anche il professor Pin, vado prima io. Okay. Voleva intervenire?
Giusto 2 parole.
Certo.
I prefer to speak in Italian in front of this audience, also because Professor Smith and I will have a trip tomorrow together from Padua to Bologna, and then I can explain tomorrow what I am talking about now.
Perfetto.
Devo dire che ho trovato estremamente interessante questa conversazione, questa lezione, questa lecture del professor Tony Smith intorno al Contempt of Court. Devo dire che la Costituzione italiana, dall'articolo 101 all'articolo 112, si occupa e dedica appunto molti articoli alla giurisdizione, alla magistratura, e si preoccupa essenzialmente, a parte l'articolo 11 nella nuova formulazione, di garantire la indipendenza e l'imparzialità giudiziaria dei singoli magistrati. E questo lo fa essenzialmente, oltre che attraverso altre prescrizioni, attraverso il Consiglio Superiore della Magistratura. E io ricordo che in Nuova Zelanda, appena scaduto dal Consiglio Superiore della Magistratura, 2 o 3 anni dopo, mi fu organizzato un incontro con Sir Ivor Richardson, che era allora presidente della Court of Appeal, New Zealand Court of Appeal, al quale io raccontai con un certo orgoglio il fatto che nel nostro paese, nella nostra Costituzione, vi fosse un organo addetto, il Consiglio Superiore della Magistratura, addetto a difendere, il giudiziario da eventuali assalti della politica, del governo. E lo dissi appunto con un certo orgoglio. Il Sir Ivor Richardson, che era una persona bonaria, un vecchietto devo dire bonario, che purtroppo adesso non c'è più, mi guardò con aria un po' di compatimento, devo dire la verità. Quando io ebbi finito mi chiese: ne avete ancora bisogno di un organo come il Consiglio Superiore? Cioè, avete ancora questo problema? Ma anche grazie in realtà al funzionamento del Consiglio Superiore della Magistratura, credo che il problema della indipendenza della magistratura rispetto alla politica, bene o male, siamo riusciti a contenerlo, diciamo, entro limiti accettabili. Però ci sono altri problemi, ecco perché la lezione del professor Tony Smith è stata importante. Altri problemi che riguardano proprio i concetti di giurisdizione. Uno l'ha messo in luce giustamente il professor Sabino Acquaviva sul Corriere della Sera ieri, quando ha parlato della corsa che ormai da molti anni molti magistrati fanno verso le cariche elettive, politiche e amministrative. E il fatto che questi magistrati, a parte la sospensione durante il periodo di eventuale elezione e di eventuale mandato politico o politico-amministrativo, possono poi rientrare in magistratura. Ecco, io credo che questo costituisca un qualcosa che va a lesionare la credibilità della magistratura, dell'imparzialità della magistratura. E quindi io penso che sarebbe molto bene se la legge del Consiglio Superiore della Magistratura, con le sue circolari, ponesse un halt a questa pratica. Perché giustamente, se è vero che i magistrati naturalmente sono liberi, come qualunque cittadino, di avere le proprie convinzioni politiche, e sarebbe veramente preoccupante se non le avessero, e hanno anche il diritto di presentarsi alle elezioni, come qualunque cittadino che lo possa fare, però ecco, il rientrare poi in magistratura dopo essersi esposti politicamente, questo io credo che sarebbe sommamente da evitare. E poi c'è un altro problema che riguarda ancora il concetto di giurisdizione che ha messo in luce bene il professor Tony Smith, cioè l'oltraggio, il Contempt of Court, l'oltraggio alla Corte, nel senso che secondo Tony Smith, e credo giustamente, il Contempt of Court è un elemento inerente alla giurisdizione, cioè chi attraverso la parte privata nei processi civili o l'imputato nei processi penali rechi attraverso condotte processuali gravemente, seriamente inappropriate e contrarie al principio di buona fede, un ostacolo serio e determinante al corretto svolgimento della giustizia e quindi all'amministrazione della giustizia e quindi all'esercizio della giurisdizione, questo è un elemento da tenere presente de iure condendo, perché effettivamente ha ragione il professor Tony Smith, questo è un vulnus all'esercizio della giurisdizione, al concetto stesso di giurisdizione come attività indipendente e imparziale in uno Stato di diritto che andrebbe anche in Italia, se ne dovrebbe tenere conto. Grazie. Adesso io mi alzo.
Ok, allora chiamiamo allora il professor Pin che interviene. No, prego.
I will switch to English.
Thank you.
I can sympathize with Matteo and Polly because I had the very same reaction when I received Silvio Riondato's call. So I feel,
can understand me.
Yeah, absolutely. Yeah, absolutely. And I'd like to take on Silvio Riondato's suggestion and reflect if it's possible to import the concept of court incident. Professor Canfreund, in that famous article, I think you mentioned the model law review article. It's a famous article published some decades ago. He says it's one thing to use some of the car's carburetor or to transplant a liver. You want to make sure you're not switching the wrong organ without being... He says that. And my impression is that it's not that easy to import your institute. And I'd like to show you why and put one final question. That's why I'm very thankful, because the paper you presented is very refreshing. It teaches a lot, which means also that I cannot speak from the height of my expertise. I can just toss some ideas. The first lesson I'm drawing is that whatever you do, don't throw anything against the judge, especially if he speaks medieval French. The second point clarifies the difference between civil law system and the common law system. So I'm trying to carve out the hidden implications of institute. As you point out, the common law institute protects justice and justiciability, both in the civil law and criminal law environments. The civil contempt is meaningful to understand how the common law system works. I just wrote some notes to be quick instead of being long. The contempt of court in the civil law field secures that court's orders are obeyed. If a court decision is not enforced, the losing party will need to face with the contempt of court. This provides us with two interesting pieces of information, which both confirm the grounds on which lays the common law. First, it is a court-centered system. If you don't obey the court's order, you are committing a breach of a legal system which is founded on courts. That's a big difference. Second, the fact that you're not obeying the court implies, rather than presupposes, that you are violating the law. So first come not obeying the court, second not obeying the law. This is because the common law flows from courts. It originates from trials, not from state. This is a very, very huge gap. But this is where the teaching lessons begin. I'm puzzled because I have Mario Patrono here. I didn't expect him to be around, and so I'm very shy today. He's a comparative law, big comparative scholar, and Professor Olivier Rosenberg is behind me, so it's hard for me to speak. We are extremely familiar with issues or defendants whose trials begin long after the public opinion has decided if the defendant is guilty. That's Matteo's point. We have largely considered the issue of ruined reputation before and independently from the outcomes of trials. The contempt of court connects reputation with fair trial. That's why it's so refreshing. I think. That's the point we're referring to. This is very comforting. I would like to draw your attention to this single aspect. At stake is not the defender reputation qua reputation. It is the reputation impact on the administration of justice that the crime targets. The crime protects the people involved in the trial and the trial itself. It is bidirectional. On one hand, it tries to avoid that coarse judge caricatures and gossips instead of real people and concrete facts. On the other hand, it protects the social acceptance of and the role of trials, in the sense that it tries to avoid that the public audience makes up its mind independently from the judicial proceedings. Think about the judges in charge of the famous Valdaosta case, the Franzoni case, after it was decided through broadcasting. It's very tough to decide a case, even for a judge, right? Let me underline the second point here. We normally try to protect an individual's reputations through imposing that the press gives full information and avoids falsity. But here we have something fuller. A fair trial may require not simply that information are given correctly, but also that information are treated attentively, also if they are true. full and detailed information can pre-decide a case. A pre-decision runs against a fair trial, even if it is correct. That's challenging for the social understanding of what fair trial is. That's my first question. So, and the second is hard even from the UK and common law systems. I'm almost done. Is the contempt of court enough to ensure that trials are fair? So it's amazing to go through the decisions that you mentioned in the paper. Take the Abu Hamza case. Abu Hamza is this sort of buccaneer pirate kind of. You can Google it. Everybody remembers it. His trial began after the Bank of England froze his funds. He was suspended as imam by the Charity Commission. The Finsbury Park Mosque was raided to seize him, and the Secretary of State deprived him of his British citizenship. Everybody knew about this before it started, or during the trial. And last but not the least, the President of the United States had called him terrorist. It's tough. Whatever one thinks, it's very tough to create a counter-narrative to all these facts. It's very tough for everybody. So is it feasible in such a globalized and media-oriented world to achieve a fair trial through the contempt of court? It's sort of triangulation. You have the judge and the jury. You have the media and you have the people. And you have to triangulate. And it seems to me that, the European Court of Human Rights decisions made, as you said, a correct assumption. Unless it's proven the reverse, Contempt of Court says that it's likely that you're going to have a fair trial. I understand that. However, it's quite interesting that the European Court of Human Rights decisions resonate with the UK decisions. The Abu Hamza case has very, very long accepts of the British decisions. It's like if the English courts were preparing themselves to be challenged before the European Court of Human Rights. The Human Rights Act, seems to me, implements the contempt ground and forces the British courts to start thinking, incorporating also the Article number 6 of the European Court Convention. And it seems to me that this resonates with your opinion that you shouldn't leave the Convention, that the UK shouldn't leave the Convention, because they've already incorporated that reasoning and getting prepared to be challenged before the European Court of Human Rights. That's the second question. But the third and most, this goes back to the first question. What has the contempt of court have to do with the issue of good information displayed before the trial begins? Not bad information, not wrong information about people, but good information about people. Does this still jeopardize the trial? Do my questions make sense?
Yes, yes, they do. No, that's very interesting insights from, as you say, a civilian lawyer, and I was very much hoping I would get something of that sort by way of feedback. The answer to your last point, if it's correct information, how does contempt of court deal with that? The point is, if it's correct, but not something that will be put before the trial court, it is or could be contempt. Because the point about our concept of a fair trial is that a person is convicted of a criminal offence only on the basis of the material considered by the court. So even if it's correct information and possibly good information, but if it's not relevant to the trial itself, the person has an extremely good character or something of that sort, that you might be able to get that in and say, look, in those circumstances it was very unlikely that the person would have done it. But no, I think it does come from our conception of trial by jury and how that should be organised. But I think your notion that in Italy trials start after the public has already made up its mind is a very interesting way of looking at it. I mean, people in England often also, depending on the nature of the trial, there are not many trials where people are absolutely sure in advance, but if it's a politician or somebody very much in the public arena, possibly. But the press just accept that they're not allowed to publish in the event that a trial is coming up. I mean, one of the possibilities that has been floated as a way of dealing with this is vetting the jury in advance. The American system, where you go to the you go through a very, very long process at the beginning of the trial, talking to jurors, potential jurors, with a view to seeing whether or not that they don't know anything about it, but whether or not they're open to or able to come to the court with an open mind and are willing to hear the case in accordance with the evidence that's presented and not in accordance with. The English courts have always resisted that. You'll be aware that the process of impanelling a jury in the United States can take a very long time. Books are written about it, about the tactics that people use in vetting or not vetting the jury, and we're just never keen to go down that route. But that is one possible way of dealing with it. But the assumption is that everybody knew, I think was the expression that you used, won't necessarily be the case. I mean, some of the people in the jury might not watch television, and one thing that you can do, and is sometimes done, if the trial is particularly notorious in one part of England, it can be tried somewhere else. It's not ideal, but if it happened in Nottingham, let's say, it can be taken down to Devon and tried there. I mean, if it's happened in London, again, you can get a change of venue to deal with it that way. But I think the press generally know that they mustn't collude with the kinds of events that you were talking about, Professor, where you've got this parallel trial going on. That just simply would not be permitted. Just absolutely clear contempt. I think again that I'm not sure that I covered all your points.
You did, I think.
Yes,
okay, thanks. Good. Yes, all right. Thank you.
Thank you very much. Thank you. So, just a few reflections about the Italian criminal law institution in order to try to find out if there are criminal offences that can somehow serve the same purpose of the contempt of court in the common law.
Yep.
It is just a try, of course, because to recall what you said at the beginning of your lecture, making a comparison between two different legal systems requires a knowledge of the law and of its social and political context that I do not have with regard to the common law system. Anyway, you gave us a vivid picture of what contempt is and what it is not in the common law. If I understand correctly, this expression refers to a plurality of conducts which are or involve an interference with the administration of justice, and therefore they enable the courts to use the criminal sanction in order to preserve or restore an efficient system of justice. The complexity of this concept and its many aspects lead us to consider that in our criminal system there is no institution analogous to the contempt of court as outlined in the common law. First of all, I think that it would be erroneous to assume a full or a partial correspondence between this concept and the offence provided for in Article 342 of the Italian Penal Code, which punishes the so-called oltraggio a corpo giudiziario. That is to say, it punishes with a fine the contempt to a judicial body. And also with the offence provided for in Article 343 of the Penal Code, that is to say, the contempt directed against a magistrate, a judge, or a prosecutor during a hearing in a courtroom. In this case, in those cases, the term oltraggio is used in a strict sense because it means insult that can be committed by the use of offensive words or behavior and so on. And the interest protected by these two provisions is the proper functioning of the public administration. And I do not know if this kind of willful, disrespectful conduct, and in particular that of insulting the judge in the courtroom, could, at least partially, correspond to a form of criminal contempt in the face of the court about what you have talked. So I ask you if this could be the case, because these are crimes in the Italian Penal Code, which are offences against the public administration, but they have obviously repercussion or reflection also on the correct functioning of the criminal proceeding. And with regard to the insult to the court, I also wonder if this misconduct could constitute a form of contempt of court by scandalizing. You told us that this kind of contempt of court has been abolished in the United Kingdom, but I'd like to know, and I wonder, if there is still the possibility to punish as criminal contempt, for example, the use of a scurrilous language or an allegation of partiality, for example, to a judge, or if there are other offences that cover the most serious forms which were covered by scandalizing the court. And in any case, in Italy, but I guess that the same issue arises also in the common law system, but I ask you about this, the punishability of the contempt of the judicial body or of a single magistrate finds a limit in the defense of legitimate criticism, which is a justification according to our criminal code. So, of course, freedom of expression includes also the right to criticize and the courts, but the problem is to draw a line between criticism, to be exempt from criminal liability, and on one side, and defamatory words on the other side. And in Italy, the tendencies of the jurisprudence is that of considering legitimate only the criticism that concerns the order or the judgment issued, that is to say, the act issued by the judge, but not the attack to the dignity of the person of the judge. So I wonder if there's the same tendency also in the common law system, to say of the United Kingdom, or not. I think that there are other offences in the Italian criminal code that seem to serve the same purpose of the criminal contempt of court. I refer, for example, to the conduct of the obstruction of justice. There's a provision in our criminal code that punishes the interference with witnesses, consultants, interpreters by offering them or promising them money or other benefits, or using violence or threat against them in order to persuade them to give a false evidence or a false statement in the proceeding. And it is also very interesting the form of the contempt by publication, which, as far as I understand, it takes many forms in the common law system, and it involves the risk of a prejudice of the right of free speech, as far as I understand. And in Italy, some of these misconducts can constitute the offence of defamation. while the publication of facts and documents of a criminal proceeding can be also punished if the publication is prohibited by the law. That is to say, for example, because the documents are covered by the duty of secrecy. And the purpose of this provision is to protect the interest to a fair administration of justice on a twofold aspect: the serenity and independence of the judge, and the dignity and reputation of the people involved in the criminal procedure. So I wonder if this could be a case of contempt by publication. With regard to civil contempt of court, I think that it is a distinctive feature of the common law system, and it's not possible to find a similar institution in the Italian legal system. I think that the only possible partial comparison can be made with the offence provided for in Article 388 of the Italian Penal Code, which is the mancata esecuzione dolosa di un provvedimento del giudice. That is to say, according to this provision, willful interference with the enforcement of a court order is a criminal offence. However, it is something different from the civil contempt, because this only covers active on one side, it covers only active interference and not mere non-feasance. And on the other side, when it also punishes non-feasance, is just it only covers the decisions of the judge concerning specific matters. It's not a general provision. And unlike the civil contempt in the common law, the nature of this provision is only punitive. So there's no purpose of coercion. It's not it has only a punitive nature. Yep. And the following criminal procedure is the ordinary one. And here is another question that I would like to ask you. So, how is the procedure of the civil or the criminal contempt? Is it different from the ordinary one? And this brief, so I can conclude, this brief fragmentary overview that I gave about the Italian legal system seems to confirm that there's nothing similar to that can really be compared to the contempt of court in the Italian legal system. And I think that it is consistent with the structure of the Italian judicial system and with the functions conferred to the judge in our legal system, because also considering that there is no jury such as the one foreseen in the common law, and the judge is both fact finder and guarantor of the procedure. So a broader power given to the judge to control the conduct of the parties involved in a proceeding could entail the risk of undermining its impartiality. That's what I think. And another concern, which is important from the view of the criminal law scholar, is that the discretionary power to punish contempt, as if I understand correctly, to identify the conduct that interfere or obstruct the correct administration of justice, and also to determine the appropriate sanction, given to the courts in the common law, seems to be very compatible with the fundamental principle of the Italian criminal law, and first of all, the principle of legality and legal certainty. So this leads to exclude the possibility of a simple transplantation from the common law to our legal system of this very interesting institution. But of course, this could be a good occasion for a discussion, for a serious reflection about the criticalities of power of the Italian criminal system and of its lack of effectiveness, about what also Professor De Poli talked to us.
Well, thank you very much for those extremely interesting insights and questions. One of the issues that I raised in the paper, but I didn't talk about in my discussion of it, was the overlap between contempt and the general criminal law. And you're quite right. There is or potentially is a significant overlap. The difference being that, as you rightly say, the procedure for proceeding against contempt is judge only. It's not jury. And so the courts have got a special form of protection, if you like, in that way. But yes, I mean, threatening witnesses, threatening jurors, and so forth are all covered in the general criminal law. I think they almost certainly emanated originally from contempt, historically, but then at various times they've been hived off, if only because sometimes it might be better to try the intimidation of witnesses and so forth by using a jury. But there is this uncomfortable overlap, and it arises with that new legislation I was talking about, which is superimposed on the common law in the sense that it doesn't actually abolish the common law. So that a person who goes searching on the web now for material that they're not supposed to commits an offence under the substantive criminal law, but equally still almost certainly is committing a contempt. And of course the importance of that is that, as you rightly say, the procedures are different. The courts have always wanted to say with something like witness tampering or corruption or anything like that, they want to strike at that very quickly, and the fastest way of dealing with that is by using the contempt power. And I think increasingly the response to that is, well, that's fine, you trigger contempt proceedings and you can do that fairly quickly, but probably it's best that you're not the one, the judge, who's going to be dealing with that. The evidence that shows that this person was in contempt. And in fact, a decision will have to be taken by the Attorney General as to whether or not it's better to go through the contempt process or better to leave it to the ordinary run. Now, there is also, funny enough, contempt in the face of the Magistrates' Court has been covered by statutes for a long time. That had to happen because magistrates don't have an inherent power. Only High Court judges have the judges of the superior courts, as they're known, have that inherent power. So in order to give the magistrates a power, yes, it was made an ordinary criminal offence to insult the magistrate, disrupt the court, and things of that sort. And I take, I think, finally your point about giving the judges another power in an inquisitorial system might be seen as imperiling the impartiality of the judiciary. I think that's a fair comment, and it's because our judges are not engaged in the collection of the facts and so forth. That's not part of their role. We still see them as using the sporting metaphor, umpires above the fray and adjudicating even-handedly as between Crown and the defence. Now, I think that covers. Just one thing about scandalising. I didn't make it plain that the essence of that was said to be that if you attack the judiciary in such a way that you actually undermine the integrity of the judiciary, not particularly the individual judge, but the integrity of the judiciary generally. If, for example, you were to say, a particular judge had found in favour of X, well, he always finds in favour of them because he's biased towards them and so forth. But that it's done in such a way that public confidence in the institution of the judiciary is undermined. Public confidence, and that's why it hasn't been used in England for so long. It's very difficult to show in a particular case where somebody certainly is just abusing the judge that there's anything like an undermining in the confidence. But I should say that it is used in certain parts of the Commonwealth in really quite frightening ways. And Singapore would be one area where the scandalising is alive, and it is much used in that particular context. And the judges say, well, whatever happens in the United Kingdom, that's not relevant to what's happening in Singapore, and so yes. we've got to do this here. But thank you very much for that interesting set of questions.
Thank you very much. Thank you for being with us, and we would like to thank you with a little gift from the University of Padua.
Oh, thank you.
This is called Osella. It is an ancient coin used by the Doji.
Right.
Okay?
Yes.
And it's a gift that every year on Christmas the Doge gave to his council, and now the Rettore of the University of Padua every year at Christmas give this coin, this medal, to the professors as a gift.
Thank you very much indeed. It'll have pride of place on my mantelpiece.
Thank you very much once again.
Okay.
Va bene, direi che possiamo chiudere. Sì. Vi ringrazio tutti, vi saluto e grazie mille.
Yeah, I echo those comments. Thank you very much. Thank you for that. That's very interesting.
No, that was very interesting.